Hello friends, today we are going to look at recent interesting case Tata Sons Private Limited versus Union of India. This is on GST levy. Let's see what the court finally decided. This was decided on 30th of April 2026, very recently in Bombay High Court. Let's look at the facts of this particular case. There was a dispute between Tata and DoCoMo. DoCoMo be a multinational company, and all these things started in the year 2009. I'm sure many of you know this DoCoMo as a brand. Tata Sons and NTT DoCoMo in 2009, they entered into a shareholders agreement for equity in Tata Teleservices Limited. But in 2014, 5 years down the line, the performance targets were not met. So DoCoMo wanted to exit. There were some RBI restrictions to block the buyback price, etc. But in 2016, couple of years down the line, the London Court of International Arbitration awarded a huge amount of US dollar 1.17 billion in damages, and this was decided against the Tata Sons. As a continuation of this 2016 verdict, the Delhi High Court enforced an award as a decree, and accordingly Tata Sons deposits 8,450 crores. DoCoMo, in turn, it withdraws the global enforcement proceedings. Whatever case, dispute, they withdrew from that. Now, the 8,450 crores, that is not the issue. Now, our GST authorities, they levied 18% on that, and they have issued a show cause notice. So the demand is 1,524 crores, IGST demand. There was a show cause notice which was issued on 26th of July 2023. So the argument is like this: the DoCoMo's agreement to withdraw the enforcement, it is equal to an independent service. And it also, according to the department, GST authorities, it constituted tolerating an act under entry 5E of the CGST Act. Then the payment also qualified as import of service under the reverse charge mechanism. This is what was the premise under which the demand was made. But the question is like that: can a compensatory payment be subject to 18% GST under an arbitral award? Can this be treated as a consideration, and thereby it amounts to a taxable service under the CGST Act? So obviously you will have a position when there is a dispute. The revenue said, or the GST authority said, withdrawal of proceedings is equal to independent service. So tolerating breach and making a payment is entry 5E. It comes under that. So they also said payment is equal to consideration for the services. Whereas the lawyers of Tata and Sons, they said payment was only for damages and hence it is not consideration. There is no independent agreement to supply anything here. Withdrawal was only incidental. Obviously, when you make the payment to DoCoMo, they will withdraw the legal proceedings. Now, the court finally hearing both the sides, they said there is no independent agreement. So, DoCoMo's withdrawal of enforcement was a legal consequence. There is no independent agreement. And this compensation, what is paid by Tata and Sons, it does not amount to consideration. So any damages under the arbitral award are compensatory in nature only. They are remedial payments for loss. It is not a consideration flowing from the reciprocal commercial transactions. And anything to qualify under 5E, there should be a consideration, quid pro quo. So, not a mere acceptance of a breach and thereby paying the consequences. There is no quid pro quo. So, the position would be incidental or integral to the satisfaction of the decree or award. It cannot be treated or elevated as a separate taxable transaction. Okay. Now, if you carefully look at 5E of Schedule 2, what it says is there are 3 elements must exist in order to charge something under entry 5E. There should be a contractual obligation. And there should be a very clear intent. The clear intent of the parties to treat such transactions as, or such toleration as a supply. And there should be a specific consideration, and the consideration should be flowing specifically for such a toleration. But actually, you know what? The court found none of these elements. And finally, the IGST demand was decided in favor of Tata Sons. In other words, the demand of 1,524 crores was quashed. So, the compensatory damage under arbitral awards are not consideration. These are the learnings which you need to carefully note. Withdrawal of enforcement proceedings after the decree is only incidental, not an independent taxable service. The revenue's interpretation, you have to look at the word, how the court has worded this. Interpretation that it will come under entry 5E is quite absurd. Underline the word absurd. And there is no legal basis. The RCM cannot apply where there is no underlying supply of service. Finally, if you are a businessman or if you are part of the tax authorities, there are 3 each takeaways from this interesting case law which was decided in the Bombay High Court. If you are a businessman, arbitral settlements are not taxable services under GST, number 1. Number 2, if you are one among the company facing such similar demands, you can cite this case law. Then the last, cross-border damages payments do not attract IGST under RCM. If you are a tax authority, entry 5E cannot be stretched to cover every contractual consequence. Tolerating an act requires separate, distinct obligation and consideration. Now, the department tends to have these kind of aggressive interpretation. You know, it can lead, sometimes the court can use such word like absurd. So the department has to be very careful. Finally, the end of the story is compensation for breach of contract is not equal to consideration for supply. And hence, GST cannot be levied on such compensatory payments. So, thank you very much. I hope this case law, which is a learning and it was interesting. And thank you very much. I will come out with more such short videos. Thank you very much.